Then we come to the third subsection of 437, which says that when a person is accused or suspected of an offence punishable with imprisonment of 7 years or more, or if he is accused of an offence under chapter 6, 16 or 17 of IPC. Chapter 6 contains offences against the state, chapter 16 contains offences against human body, and chapter 17 contains offences against property. So if anybody is accused of an offence against the state, or of an offence against human body, or of an offence against property, then when he is released on bail, court shall impose conditions on him. He may be released on bail, there is no prohibition, even in respect of offences against the state. He may be released on bail, but at the time of release, court shall impose these conditions. Let us see what are these conditions. These are mandatory conditions in every case of release under when the accused is facing these charges. The first condition is that such person shall attend in accordance with conditions of the bond. That is quite simple and normal. Yes, he must attend in accordance with the conditions of the bond. Needless to say, even without saying, he has to attend. Secondly, such person shall not commit an offence similar to the offence of which he is accused or suspected, as if he can commit any other offence not similar to the offence of which he is accused. The condition should be that he shall not commit any offence, but yes, here the condition is only this much, that he shall not commit an offence which is similar to the offence of which he is accused. Third, such person shall not make any inducement, threat or promise, ITP. He shall not make any ITP to any person who is acquainted with the facts of the case. Who is this person acquainted with the facts of the case? This is the person whom we call as a witness. So, the condition is that the accused, after release, shall not make any ITP to a witness so as to dissuade him from disclosing such facts to a court or to a police officer, and such person shall also not tamper with evidence. And lastly, it's an open condition. Court may also impose such other conditions as it considers necessary in the interest of justice. So any other condition may also be imposed. These are the conditions which must be imposed when bail is granted to a person who is accused of an offence which is punishable with 7 years or more, or who is accused of those specified offences under chapters 6, 16 and 17. Subsection 4 says that an officer or court releasing any person on bail shall record in writing reasons or special reasons for so doing. That's elementary. Reasons must be recorded. So subsection 4 is just stating the obvious. From here we can see that under section 437, release on bail may be given either by a police officer in charge of the police station or a magistrate's court, and reasons are to be recorded. Special reasons are also to be recorded in certain cases. We have already seen in which circumstance special reasons are to be recorded. Subsection 5 of this section empowers a court who has released a person on bail to order his rearrest and commit him to custody if it considers it necessary. But this can be done only by a court which has released that person. Now, an order for rearrest of a person can be made by a court. That is one thing. And here, by the court means by the magistrate court. Please remember, in section 437, we are dealing only with a magistrate's court. Sessions court and high court are separately dealt with under section 439, not under section 437. So the word court in this section means the magistrate's court. So a person who has been released on bail may be rearrested under orders of a court. Of which court? Only of that court which has released that person on bail. Now two things are to be noted here. Firstly, when bail has been granted by a police officer, he cannot order his rearrest, because this power to rearrest under section 437(5) is granted only to the court, not to the police officer. And second point to be noted is that the court can order for rearrest only if it was the court which had released him. So if the release on bail was given by the police officer, then court also cannot order for his rearrest if you go by the bare provisions of subsection 5. Then lastly we have 437(6), which deals with a case which is triable by a magistrate, and obviously we are dealing with non-bailable offences in this section. If trial in such a case is not concluded in 60 days from the first day fixed for taking evidence, the 60 days to be counted not from the date of charge sheet, it is to be counted not from the date of filing of FIR, it is to be counted from the date which is fixed for taking evidence. And 60 days time is given to conclude the trial. If it is not so concluded, then the accused shall be released on bail. It's a mandatory provision. If the trial is not concluded within 60 days, accused shall be released on bail. And it's left to the discretion of the magistrate not to release him if there are strong reasons which are to be recorded in writing for not releasing.